Hi, welcome back to the Diary of a Barrister. I'm Chelsea Brooke Ward. I'm your host. I'm an employment barrister at Park Square Barristers. And today we're going to be talking about how to make your case. So this episode is aimed at law students at any stage of their journey in England and Wales, of course. Whether you're in your first year of an LLB, halfway through a GDL, on the LPC or BPC, or staring down the SQE, wondering how on earth you make yourself stand out. We're going to cover what it actually means to be a trustworthy risk in legal recruitment, the habits and experiences you should be building right now, and critically, how to use all of that evidence when the interview questions come. So whether you're listening to this on your commute, in between seminars, or at your desk with a stack of books you're very pointedly ignoring, I'm really glad you're here. Today, we're talking about something that doesn't get nearly enough airtime in legal education, and it's this. You actually get the job. Not the application form tips, not how to smash a specific firm's competency questions. I mean the deeper question of why some candidates are chosen and others aren't, and what you can do starting now to be the one who is. The phrase I keep coming back to is this: recruiters, whether they're a pupillage committee, a set of chambers, or a graduate recruitment team at a Magic Circle firm, are making a bet. They are taking a risk in you, and the question they're trying to answer in every stage of your application is this person trustworthy? Not perfect, not flawless, not someone who's never made a mistake or never been uncertain, a trustworthy risk. Someone they can rely on, someone whose character they can read, someone they can put in front of a client, courtroom, deal, and feel confident about it. And here's the thing. You cannot manufacture that overnight. You cannot fake it with a polished application form, but you absolutely can build it deliberately, strategically, over time. And that's exactly what we're going to talk about today. And I want to be clear. This episode is for you wherever you are in your journey. If you're in your first year of an LLB and thinking, is it too early to be thinking about this? Absolutely not. It is not too early. In fact, this is exactly the right time. But if you're on the BPC or LPC and you feel like you've left it a little bit late, you haven't. Start now. Every stage of training has something to offer. We're going to cover both barrister and solicitor routes today because while there are important differences, there is far more overlap than most people first realise. So, without further ado, let's get into it. So let's start with a bit of grounding, because I think it's worth being really clear about what each route involves before we talk about what you need to do to succeed it. Not because you don't know, you probably do, but because sometimes we're so focused on the mechanics that we lose sight of what recruiters are actually looking for at each stage. So if you are going down the solicitor route, your qualification path, particularly post-SQE reform, involves completing your qualifying law degree or conversion, passing the solicitor's qualifying examination and completing 2 years of qualifying work experience. And many of you will also have sat or be sitting the LPC, which is still a perfectly valid route as well. But here's what I want you to really absorb. The training contract or the QWE period, qualifying work experience period, is not just a tick box exercise. A firm is essentially making a multi-year investment in you. They're saying, we believe you have the potential to become one of our lawyers. And then they're going to spend significant time and money training you, supervising you, integrating you into their team and their culture. And that is a huge commitment on their part. So when you walk into a training contract interview or a vacation scheme or even an open day, the question hovering in the back of every recruiter's mind is, would I trust this person with one of our clients? Not today necessarily, but in 2 or 3 years with the right supervision and training. Could I see this person being someone I can rely on? And if you're going down the barrister route, you're going for the bar, the mechanics look a little bit different. You'll complete your academic stage, sit the bar practice course or the bar training course, depending on your provider, and then comes the crucible, pupillage. 12 months split between a non-practicing and practicing 6. And unlike training contracts, pupillage spots are extraordinarily competitive. The bar is a smaller market. It's tighter. The standards expected at application is frankly extremely high. Pupillage committees are evaluating you through a very particular lens. They need to know that you can handle pressure, that you can think on your feet, that you can be trusted to represent a client, sometimes at the most critical moment in that client's life, with integrity and competence. And they're trying to work all of that out from a written application and usually 1 or 2 rounds of interviews, so 2 hours out of your whole entire life. Sometimes that might include a 30-minute assessed exercise, but the time in which to make that decision is very, very narrow compared to how many years and experience you've actually lived. Now, the other thing I want to flag is that the bar isn't one homogeneous thing. Criminal sets, civil sets, chancery sets, commercial sets, family sets, public law sets, the list goes on. And they each have their own culture, their own expectations, their own idea of what the ideal pupil looks like. So while everything we're going to cover today applies broadly, I want you always to be thinking about how it maps to the specific practice area that you might be targeting. And here's what I want you to hold on to as we move through this episode. Despite the differences in structure, both routes are fundamentally asking the same question of you. Can we trust you? Do you have the character, the judgment, the commitment, and the self-awareness to grow into the lawyer we need you to be? Everything, and I mean everything, flows from that question. And it really is that simple. The difficulty comes with proving the evidence to substantiate your answer to that question. And I want you to spend a bit of time unpacking this phrase because I think it's genuinely useful as a frame for everything you do during your studies. When a recruiter says they want to see potential or drive or commitment to the profession, what they're really asking is, can I trust this person? And that question has a few different dimensions. And the first one I want to touch on is reliability. Will this person do what they're saying? Will this person do what they say they're going to do? Will they meet deadlines? Will they come prepared? Will they follow through? And I know this sounds basic, but it is genuinely foundational. In law, as I'm sure many of you already know, missing a deadline can have catastrophic consequences for a client. Forgetting to file a document, overlooking a detail in a contract, failing to research a relevant case. These are things that matter enormously. So when recruiters are looking at your application at interview, they're looking for evidence, concrete, specific evidence that you are somebody that can be relied upon. And the second dimension is integrity. And this is where it gets a bit more nuanced because integrity isn't just about not doing bad things. It's about doing the right thing, even when it's difficult. It's about being honest about what you don't know. It's about flagging a problem even when it's embarrassing. It's about putting your client's interests first when it's inconvenient, even to yourself. Recruiters are particularly attuned to this. They're looking for people who won't take shortcuts, who won't cut corners, who understand the legal profession carries with it obligations that go beyond winning. And the third dimension is self-awareness. This is something I think a lot of law students underestimate. Recruiters, especially at interview stage, are not looking for somebody who thinks they know everything. They're looking for someone who knows what they know, knows what they don't know, and has the humility to ask for help when it's needed. Overconfidence in a trainee or pupil is genuinely alarming. Self-awareness, on the other hand, is a signal that someone will be coachable and they'll take feedback well, grow quickly, and not create problems by pretending to understand things that they don't. And finally, there's commitment. Not just, I want to be a lawyer because it's prestigious, but a genuine evidenced commitment to the profession. And this means understanding what the job actually involves, having engaged with it in real and meaningful ways, and being able to articulate that. Recruiters here, I've always wanted to be a lawyer, all day long. What they want to hear is something specific about why you want to be a lawyer. And I come back to this framework of the 5 whys. If you don't know why you want to be a lawyer, ask yourself 5 whys. I've spoken about that in a previous podcast, so I won't go through it again today. But if you Google the 5 whys, it will bring up that framework for you to follow. Because what they want to know is that it's not something that you haven't thought about. when you have that motivation or you have that why, something that shows that you've thought about it, you've experienced it and know what you're signing up for, it makes a much more compelling, persuasive, impactful answer. The mindset shift. And I think this is really important here. And it's this: stop thinking of your time as a law student as a waiting room. It's not a period you have to get through before your career starts. It is your career in its earliest form. Every piece of work experience, every case you analyse, every pro bono client you help, every meeting competition you prepare for, these are not extracurricular activities. They are building the blocks of your professional identity. And the recruiters who see them in your application or hear about them in your interview are using them to form a picture of who you are. So build the picture you want them to see, deliberately, consistently, and over time. Packing and cramming all the experience into a couple of weeks does not show that you are somebody that's reliable and trustworthy. It shows that you are somebody that's last minute, unorganised, and cramming into the last bit of time that you have. I wouldn't want to put my liberty in the hands of somebody that dealt with their life in that way. So let's get practical, because these are the habits and activities that apply to you regardless of whether you go for the bar or the training contract or a paralegal role or any role for that matter. Think of these as your foundation. Everything else we're going to talk about is built on top of these, okay? So the first is you need to develop your legal and commercial awareness as a habit, not a sprint. And I cannot stress that enough. Legal awareness, understanding what's happening in the law, in the courts, in Parliament, is not something that you can cram before an interview. Understand it and be able to respond and ask questions about it, because you just won't be able to build the mental resilience and capability to remember everything, and then you'll panic. Whereas if this is something that you do slowly, steadily, over months and years, you're much more likely to have a more articulate opinion, response, and ability to deal with any such type of questions. Because even if you didn't know about the specific commercial awareness question that you may be asked, you may have read something or seen something in the past that gives you something to talk about. And what does that actually look like? Well, it looks like this: reading the legal press regularly, the Law, the Gazette, the Lawyer, Legal Cheek, Council magazines, Supreme Court judgments, watching them online when they drop, even just summaries, employment tribunal judgments online. It looks like following cases that interest you and being able to talk about them with genuine engagement, not just surface level recall. It looks like understanding, for commercial solicitors, what's happening in the economy. Reading the Financial Times, understanding what a deal actually is, knowing who the major players in your target practice area are. And here's the thing: if you do this consistently, over time, when you walk into an interview and they ask you about a recent legal development or commercial issue, you're not guessing. You have an opinion, and that is incredibly powerful. And if you can evidence that you don't just have an opinion on something recent, for example, but you can link that to something that you'd read X amount of months ago or X amount of years ago, to evidence the fact that this is not something that you've just crammed in before the interview, but it is something that you repeatedly do consistently for the past however many months, that shows that you are somebody that's taking this seriously. That shows that you are somebody that's committed. That shows that you are somebody that's disciplined and knows what it takes to understand the things you need to understand. So set aside 20 minutes a day, 20 minutes, 10 minutes if you don't have 20 minutes, which I don't agree, to read one article in an area of law that you're interested in. Follow one case that you're interested in, an area that you're interested in. Understand a complex deal that's going through in some of the big players. And take notes. Write notes down on each day that you've done it. And after 6 months of that, I guarantee you will be in a genuinely different place to someone who hasn't done it, for a number of different reasons. You will have built up the skill of reading complex, nuanced, complicated, voluminous documents. You will also more readily understand those particular areas of law, but you will also understand to a larger degree some of the terminology that is used, the legal jargon, and your vocabulary will be much larger than it was when you first started. Pro bono is one of the most underrated things a law student can do. And I think a lot of people see it as a nice to have rather than what it actually is. And I think a lot of people also treat it as a tick box requirement to have on their CV, an application form, and really forget about why they should be undertaking pro bono in the first place, which is an opportunity for you to develop real legal skills, make a real difference to people's lives, and demonstrate to recruiters your commitment to law goes beyond just a paycheck. It is your training ground, your playground, if you like, to get real hands-on experience and develop the identity of the lawyer that you want to become. It's a place where you can implement things by trial and error. And I don't mean that in the way of taking risks on behalf of clients unnecessarily, but I mean the way that you speak with a client, the way that you prepare a case, the way that you communicate the case afterwards. All the little nuanced bits that you can add your identity to as a lawyer. This is the place where you can really, as I say, experiment. It's also the place where you can build up confidence. If you have never ever done a client conference before where they're looking at you, expecting you to know all the answers, it is a daunting experience, even if you know all the answers. And so it is a great place to start building up that confidence, because remember, confidence is not something you're born with. It's a muscle that you build over time. And most universities have law clinics or have partnerships with organisations like the Citizens Advice Bureau or with charities that need legal research. The Bar Pro Bono Unit and Advocate exists specifically to connect barristers with pro bono cases. And while you're a student, getting involved with organisations that support those efforts puts you ahead of the pack. Because what does pro bono show? Well, it shows initiative. It shows that you understand that the law has a social function, not just a commercial one. It shows that you can handle real, sometimes emotionally complex situations with professionalism. And it gives you brilliant material for interview. And what I would suggest practically is that when you do any pro bono work, write down what it was, write down what you learned, write down what you found surprising, write down what you found exciting, because 6 months, 12 months, 2 years from now, you'll have forgotten. And then you have nothing but nonsense to put on your application form. So do yourself a favour and keep a record. Networking, building meaningful relationships, not just a network, not just a list on LinkedIn. Networking is a word that makes a lot of people uncomfortable. And surprisingly, a lot of lawyers and wannabe lawyers uncomfortable. And I think it's because we misunderstand what it is. Networking is not handing out business cards, pitching for work, or collecting LinkedIn connections. It's building real professional relationships, friendships. It doesn't always need to be about a business transaction. I want to do this for you to get paid, etc. It's about building people that you can turn to if the need arises. And that might be because you're in the same area of law and you've got a complex matter you want to run past them. It might be because you want a business relationship with them. It might be because you want a mentorship. But building real professional relationships with people who are doing the job is an absolute must for any wannabe lawyer, because you just don't know when you will need them. So, for example, I want to tell you about a story in my professional journey. I applied for a mini pupillage at Chambers and was successful. I was driving to Chambers on the morning, all suited and booted. I'd been up since about 5 o'clock. I ironed my suit about 7 times before. And on the way, I dropped my daughter off at school. I was sat at the traffic lights waiting for the lights to turn green when a bird kindly opened its bowels through my window onto my freshly pressed suit. So I had to go home, had to get changed, had to iron another suit. I was absolutely panic-stricken. But this particular Chambers had the practice of taking mini pupils on the same day, lining them up in the order that they arrived, and then assigning the next barrister that walked through the door to first in line, which meant that I didn't get the mini pupil supervisor that I would have got had I turned up without bird crap all over my suit. But that turned out to be the best thing that ever happened in my entire life, because the mini pupil supervisor that I was ultimately assigned to gave me so many contacts within the legal world. I was invited back on a number of occasions to do mini pupilages with him. And I kept that line of communication going. And he was quite surprised that there was a number of law students that didn't do things like that. And I was constantly saying, is there anything I can help with this week? What are you looking at this week? Is there anything exciting? Do you need me to do any drafting? And I was constantly trying to add value to him so that I could get the value of shadowing him. And I think a lot of people look at mini pupilages as a right, as an entitlement, and as something that they have earned, which to a degree is, but I can't tell you how difficult and time-consuming having somebody shadow you for a week is when you are inundated with work already, without having to explain the things that you're doing, without having to take the time out to meet them on a morning, to have lunch with them, but also just the bandwidth of having somebody with you when you're usually on your own in your own autonomous little bubble. It takes a lot. And so for barristers to do that, I think students need to understand how much it takes and try to add value to that. But I've gone off piste a little bit. So he invited me back on a number of occasions, and ultimately he became my pupil supervisor. For this reason, I was offered pupillage at another set of chambers. And when it came round to my pupillage starting, the pupil supervisor that had been assigned to me, in fact, left the chambers, which meant I had a pupillage but no supervisor. And because I'd built up this good working relationship with this barrister from Leeds, I went to him and said, look, this is my situation. You know, what can I do? And he was foundational and instrumental in the next steps, which ultimately is the reason why I'm sat here now. He was like, well, this is what you can do. We'll write to the chambers where he was at so that I could do a secondment there, which meant that I would be doing my training with them with a view to going back to the other chambers. He helped me write the application. He gave me a reference in respect of that application, and ultimately that application was accepted. And then when it came to going back to my original chambers, he also was instrumental in helping me make an application to stay, because by that time, and before, I must admit, I'd fallen in love with this chambers. It was my first choice chambers. That would not have happened had I not built that working professional relationship. So it just goes to show how important it is, but also how rare it is for students to keep open that line of communication. Those that have been offered it before me may just have missed the opportunity to get pupillage because of it. So I want to stress the importance of building a professional relationship. Aside from mini pupillages though, how do you do it? Well, you can go to events. Barristers' chambers hold seminars and events all the time. They're mostly directed at solicitors and clients with a view to building working relationships with them. But if there is something that takes your interest, it might be an area of law that you have an interest in, or there might be attendees such as barristers that you would like to connect with for varying different reasons, write to the chambers and say, I've noticed that you've got this event coming up. I know that it's directed at solicitors. I'm a law student. I'm in X stage of my legal career. These are the reasons why I want to attend. Would that be possible? 9 times out of 10, they will probably say yes, unless there is some pressing reason that they wouldn't want law students there. You can attend your in-student events if you're heading to the bar. Firm open day and events for trainee recruitment. But the importance about these events is not just attending, it's speaking to people whilst you're there. And that is for 2 reasons. You're never going to build a network unless you communicate with the other side. firstly. And secondly, the more you go to these events and the more you communicate with people at these events, the more confident you will be at doing so. So not only will you be building your network, you will also be building your confidence. You can go to lectures at your university. There might be extracurricular activity. They might put on events where legal professionals attend. Reach out to practitioners politely, concisely, specifically, and ask for 20 minutes of their time to hear about their experience, or whether they can point you in the direction of a mentorship, or whether they would be willing to be a mentor. Don't ask, don't get. That is my motto. If they ignore you, don't take it personal. They're probably just very busy. And if they say no, likewise, don't take it personal. They're probably very busy. It is not a reflection on you. But if you show that initiative and somebody does say yes, well, that could just change the trajectory of your career. And really importantly, really, really, really importantly, when you do speak to people, listen more than you talk. This is a learning experience. And if you're doing all the talking, you are not learning. Ask good questions. Be curious. Follow up with a thank you email that references something specific from your conversation. People remember that. Everybody, you, me, the king, for God's sake, like to hear about themselves. And a good thing, if you are networking with somebody, is to remember that. And when you communicate with them, direct your communication at them. So, for example, I noticed that you did this and I thought that was really interesting. Can I just ask, why was it that you approached it that way? Give them a compliment, rub their ego a little. You will be remembered. But if you don't ask questions, you don't look like you're getting the most out of it. You look bored. You may be remembered, but for the wrong reasons. And when they're later sitting on an interview panel, or mentioning your name to a colleague, that could go one of two ways. You could be remembered as being curious, engaged, genuinely interested, somebody that's positively remembered, or you could be blackballed. So when you are networking, there's no use in going and standing in the corner quiet. You won't be seen, you won't be heard, you won't be remembered, and you'll learn nothing. It will be a waste of your time. Be consistent and reliable in everything you do, not just your legal studies. Everything you do, be consistent and reliable. Anything that is a priority to you at that stage in your life needs to be consistent and reliable, because this one is about character. Everything you do during your studies is a rehearsal for what you'll do in practice. And if you say you'll turn up to something on time, turn up on time. If you commit to a pro bono case, see it through. If you join a society, actually show up. If you say you'll do something for a supervisor or a mentor, do it. And do it to the best of your ability. It sounds obvious, doesn't it? But you would be surprised how many people don't do this. And the thing is, legal world is a small world. Word travels. Reputation is not just built in formal settings, but it's built in these small moments, these everyday interactions. And it really, really matters. Now, develop your writing. Whether you're going to the bar or a firm, the ability to write clearly, concisely, and compellingly is not an option. It's absolutely a core skill, and it's a skill that compounds in practice. So write regularly. And I'm not just talking about essays for your degree, but deliberately write a case note on a judgment that interests you. Write a short article for a law school's journal. Start a blog if that appeals to you. Enter essay competitions. There's dozens of them run by chambers, firms, bar council, law society. Google it. They take effort. They take time. Yes, but they give you a tangible credential and force you to really engage with a topic at depth. And if you are somewhat successful in those processes, it gives you that evidence to show that you can articulate yourself in writing to such a degree that is trustworthy. Engage with your inn or law society. For aspiring barristers, your Inns of Court is not just a historic building where you eat dinner set that looks a little bit like a Harry Potter scene. It's a community, a network, and a resource. Attend educational events. They are constantly and consistently putting on schemes, initiatives, etc., to help people in your position. And not a lot of people take up on it. Go to qualifying sessions with a genuine intent. Speak to people when you're there. Take advantage of these mentoring schemes. The relationship you build with your in can and will last your entire career. And for aspiring solicitors, your University Law Society, Junior Lawyers Division, Local Law Society, all opportunities to build your professional community and your profile. Get involved. Take on a role, help organise something. Leadership within student organisations is genuinely impressive to recruiters when you can articulate what you learn from it. Okay, now let's get specific, because while everything we've just covered applies to both routes, there are particular actions that will really move the needle depending on the path you're intending to take. So for aspiring barristers, mini pupillages, how to get them and what to get from them. Mini pupillages are, without question, one of the most important things you can do if you want to go to the bar. They're not optional extras, they are expected. And more than that, they are a genuine opportunity to understand whether this is actually the right career for you, and to demonstrate to chambers you have the appetite and the aptitude for it. So getting them, start early. There is always the question, how many is enough? This is not a tick box exercise. 1, 2, 10, 15. What matters is what you learn from them. So how many is enough is a how long's a piece of string situation. Many chambers have formal application processes and specific windows. Some are competitive, particularly commercial and criminal sets. Apply broadly, especially when you're starting out. Yes, you should aim for your dream set, but spend time in different practice areas too, because you will learn something from all of them. And whether it's that you've learned that you don't want to do that area, great. You can say that when you're asked specific questions about why the area you are choosing. And you'll have much more interesting things to say in interviews. But what to get from them? Don't go in passively. And this is a massive, massive issue I've seen from people that I've had shadowing me, is that they just simply turn up and observe. I personally don't understand or see what benefit they got from that. Because observing a barrister on their feet is half the story. The hard work goes into the preparation that they do outside of court. And if you are just watching them do the conclusion of their work without asking any questions, then you're not really benefiting from the experience. If you also turn up and you haven't done any pre-reading about the particular matter that you're observing, you're going in there blind as well. So not only are you only getting to experience half the situation, another large part of it is cut off because you've not got to Scooby-Doo what's going on. So ask if you can have a summary or the papers in advance. There might be particular reasons why some of those documents can't be provided to a third party, but you can at least ask the question. Ask thoughtful questions about how they prepared. Each barrister has a different way. Ask questions about why a question was asked that way, if anything took you by surprise. Ask how they prepare a case. What do they start with in this type of case that they're doing? Take notes. The amount of people that turn up without a pen or a laptop and just sit there like they're watching an episode of Coronation Street is surprising. Take notes. Be valuable to that particular barrister. Because remember, I've already spoken about how much effort and time it takes for the barrister to have somebody shadow them. So show a little gratitude to that process and see whether you can add value to them. And when you take notes, it might be a good idea to ask them what they would like a note of. Because again, each barrister has their own particular style. So for example, if somebody was taking a note for me, I don't need them to take a note of the question that I'm asking because I already have a note of that. But a note of the verbatim answer that I got to my question is really helpful for me. Whereas some barristers might want both. Some barristers might only want a really detailed note of a specific part of the evidence. So ask the question, Would you like me to take notes? What format would you like them in? How can I make it easier for you? It shows initiative. It shows understanding. It shows you understand how difficult this job is. And let me tell you something, taking a note of evidence in a hearing is a skill in itself. And when you come away, write up what you observed, what you learned about it, not just for interview purposes, but so it actually sticks and so you actually think about it. Because the amount of people that just go into these experiences passively and don't even think about anything that they've learn nothing. The detail you can recall from a mini pupillage when you're in a pupillage interview, 9, 12, 24 months later, is what separates out good answers from great ones. Mooting is the lifeblood of a barrister. And I think most law students know that. But I want to go a step further and say, don't just moot. Engage with mooting at a deeper level. Watch moot court recordings. Watch Supreme Court hearings. Attend court hearings in person when you can. Most courts are public arenas and you don't need permission to go. Just turn up to a court and say, where's there a public hearing? Where can I observe? The more you understand how oral advocacy actually works, the better you will be at it. And the more varied types of oral advocacy that you see, the better you will be at it. So don't just enter the one mooting competition and prep that one case. Enter that mooting competition with as much preparation as you would the pupillage interview. And when you're preparing for a moot, go deep into the legal arguments. Don't just memorize your submissions. Understand them. Know the brief, the bundle, the witness statements, the area that you're arguing about it. Know it off by heart. You should not need a script that you read from. You will not get anything from that. A script will do more harm than good, and you will not be doing yourself a justice if you have a script that you're reading from. And be able to argue both sides. Don't just look at it from your side. Know what your counter arguments are going to be. Know what you're coming up against and take the sucker punch out of it. Deal with it in your submissions. Don't wait for the other side to make it. Make it yourself. Judges and later pupillage interviewers will probe reasoning around some of the answers that you give. And the ones who shine, from my experience, are the ones who've thought about it properly and not just rehearsed a script. They know their good points, their bad points, and the likely points that they have to come up against. And they know it. And the most important preparation motto for a barrister is know your brief. You know the brief for this one case, then you shouldn't need a script. You should be able to answer the questions because you've done the reading. You know what your case is. You know what their case is. You know what the law is. You know what the principles and the judgments say. You know it because you've prepared it enough that you know it. Marshalling. If you have the opportunity to marshal, that is to shadow a judge for a day or a week or a couple of days, take it. It gives you an extraordinary insight into how decisions are made, what judges value in advocacy, how the courtroom actually works from the inside. But it also gives you fantastic things to discuss at interview. And let me tell you, looking at a case from an objective standpoint is very, very different than if you're shadowing a particular barrister for one side, because naturally you become a bit subjective and biased to their point of view and their client's point of view. But when you're sat with a judge and you're looking at either side, you don't really go in there with any preconceived ideas about what the case is and who should win and who shouldn't. You are looking at it from an objective standpoint, and it really gives a bit more clarity to advocacy, seeing two different barristers argue a point. And the experience is completely different to shadowing a barrister. Again, if you are doing this, write it up afterwards. Write up your reflections, not just so that you can remember them later down the line, but so that it applies your mind to the things to look out for, things that you have learned, and have some banked information to come back to when you need it. Essay competitions and academic writing. The bar is still very much an academically rigorous profession, don't get me wrong. Strong first-class degrees are expected at the top sets, but beyond grades, there are essay competitions. These are a way to demonstrate that you can engage with complex legal questions independently and produce high quality written work. Inner Temple, Middle Temple, Gray's Inn, Lincoln's Inn all run essay competitions. Specialist bar associations such as the Com Bar, the Chancery Bar Association, the Criminal Bar Association, all often have their own events and competitions. So keep an eye out. Keep yourself a journal, keep yourself a diary of these upcoming opportunities, and know your practice area. Now, I get it. Some people don't know what they want to practice, but you've got to have an understanding of the type of person you are and the type of life you want to live. And that should, to some degree, point in some certain directions. Here's something that surprises students sometimes. Barristers are generally specialists. And the pupillage process particularly at the second interview stage, often involves really digging into your knowledge and passion for specific areas of law that you want to practice. So if you want to become a commercial barrister, you need to understand commercial law at a level beyond what you studied in your seminars. Read the leading cases, read the commentary, read the journals, know what the hot issues are. Same goes for criminal, family, public, wherever your passion lies. If you haven't got a passion, then I suggest you try and identify what you want your life as a barrister to look like. Because if you want the unpredictable, exciting type of life, then the criminal bar is probably for you. If you don't want to step foot in a courtroom because it could be the worst thing that could ever happen to you, then the commercial bar is probably for you. If you want to be working with children and education or the family bar, if you want a mixture, then a common law pupillage might be for you. But you need to start asking yourself some of these questions about where do you see yourself in 10 years' time? What does your life look like? And does that help you narrow the pool so that you can start more focused experience to build those steps up to the pupillage interview stage? And if you can't, then throw mud and see what sticks. Now, vacation schemes, preparation is everything. Vacation schemes are the primary route to a training contract at most major firms. But here's what a lot of students get wrong. They treat the vacation scheme as the destination when really it's just an extended interview. Firms are watching everything. How you interact with partners, how you treat the trainees, how you approach the work, how you handle feedback, whether you show up early or on time, whether you ask good questions, etc., etc. Preparation for a vacation scheme means several things. It means understanding the firm, not just the headline, what we do on their website, but the actual deals, the cases they've been involved in, the sectors they focus on, who their major clients are, how they differ from their competitors. It means being ready to contribute meaningfully to the tasks you're given. And it means being yourself, because pretending to be something you're not for 2 weeks is exhausting and ineffective. Trust me, I've been there. I've got that t-shirt. It means asking good questions. Good questions are one of the most powerful signals of intelligence and genuine interest. Not how many hours do you work, although that's a fair thing that you'd want to know, but questions that show you've thought about the firm, the work, and the career. Develop genuine sector knowledge. Most commercial firm lawyers don't just practice law in the abstract. They advise clients in specific industries: finance, tech, real estate, energy, healthcare, media, etc. And recruiters increasingly want to see that you have genuine curiosity about the business world, not just the law. So pick a sector that genuinely interests you. Read about it, follow the major players, understand the regulatory landscape, know what's happening, whether there's an M&A trend in the tech sector, developments in the energy transition space, or regulatory change in financial services. When you can talk about a sector with real knowledge and genuine enthusiasm, it is incredibly compelling. And if you do all that reading and you realise, actually, this is not for me, great, move on to something else. You're not going to waste your time applying to an area that actually, when you've read into it, you don't much care about. Open days and early insight programs. Many firms offer first-year insight programs, spring weeks or open days. And they're not just nice to have. They are an opportunity to get noticed early, to build a relationship, network with a firm before the formal recruitment process begins, and to demonstrate initiative. Apply to them. Prepare for them as you would any professional interaction, and follow up. afterwards. Beyond the firm, other legal experience. Don't just focus on your target firms. Varied legal experience, legal aid firms, in-house departments, public sector organisations, charities give you a much richer understanding of what the law does and how it operates across different contexts and how it influences and complements each other. And it gives you a broader story to tell in interviews. Someone who has worked in a legal aid firm, done a vacation scheme and volunteered at a law clinic has much more interesting and textured answers to tell me about your legal experience than someone who's done just one thing or nothing. So you've done all the hard work. You've implemented all the habits consistently, repeatedly for a period of time. You've done the work. You've built the experience. Now we need to talk about how you translate all that into interview gold. Because the most common thing I see is students have actually done brilliant, really genuinely impressive things and then undersell that completely in the interview room because they talk fluff. So let's change that. The first thing I want you to do, and I mean literally do this, not just nod along to it, sit down and write out every single thing that you have done that is relevant to your legal career. Every piece of work experience, every responsibility you've held, every challenge you've navigated, every moment where you've demonstrated the quality recruiters are looking for in your particular area. Write them all down in as much detail as you can remember. And if you are in a situation where you don't know the sector or the industry or the area of law that you want to go into, then you need to do this exercise a couple of times because you will want to do it under each sector, area, industry, because each has different skills. And for each skill, we want to be able to relay experience that identifies we have that skill. And we need it to be laser focused. So do the exercise for each industry, area, sector. Now, this is your evidence bank. And the reason it matters is that when you're in an interview and someone asks you to demonstrate competency, problem solving, teamwork, commercial awareness, ethical judgment, you don't want to be rummaging around. You don't want to be rummaging around in your memory under pressure. You want to already know which stories you are going to tell. And having the whole experience set out in this way, you can then start to cherry pick the best pieces of evidence that you have. And from that, you may be able to identify that there is a number of different experiences, situations, or challenges that could speak to a number of different questions. And remember, when you're in an interview, you do not want to overwhelm the interview with so many different stories that they simply cannot remember. Too much information is information overload, and you don't want to be doing that. So if you could have 4 to 5 different scenarios to be able to answer the majority of the questions, in my opinion, that is better, because then you can say, well, I spoke to you about X scenario. As part of that process, this also happens. So then really painting this picture in their mind of this particular situation. And when they can paint a picture in their mind, pictures are remembered more than words. So how do you answer? There's a number of different frameworks that you can use to answer questions. We can use the prove method, which is on a previous episode, which I'm not going to go through. Or you can use the STAR framework. And you've probably heard of this: situation, task, action, result. For me, I didn't really find this very helpful, but most people, or some people, do. It's popular because sometimes it does work. But what I want to add is a 5th element, the reflection. So let's call it the STAR R. So the situation, what was the context? Set the scene briefly, but with enough detail that the interviewer can visualize it. We want to get to that visualization aspect. And then what your specific role or responsibility was within that context. What were you trying to achieve? Action, what did you do? And specifically, you do. Not the team, not somebody else. What decisions you made? What steps you took? What was the reasoning behind your approach? And what happened as a consequence of your actions? Be specific, quantify where you can, and be honest. Not every story has to have a perfect, happy ending. Sometimes the result was that you learned something important and not to do it again. Reflection. What did you take away from that experience? What would you do differently? What does it tell you about yourself? This is what separates out good candidates from great candidates. Interviewers are not just listening to what happened, they're listening to how you think about what happened and how you review and reflect yourself, because that tells a lot about a person. It tells whether you're resilient. It tells whether you have self-awareness. It tells whether you are objective. It tells whether you are coachable. But most importantly, if you are able to objectively reflect on the decisions that you make, it shows that you are trustworthy. Now let's run through some of the most common questions and think about how you map your experience to them. So tell me about a time you had to deal with a difficult situation under pressure. A resilience question. Recruiters want to know that you can keep it together when things get hard. Think about your evidence bank, a difficult mooting match, a last-minute change in a pro bono case, a challenging academic period, a work experience placement where something went wrong. Tell the story crisply. Don't dramatise it, but don't undersell it either. And make sure you get to the reflection and make sure you specifically identify what it is that you did as part of that challenging scenario. What did you learn about how you perform under pressure, and how can that add value to the chambers or to the firm? Give me an example of when you had to demonstrate integrity. This one of the most important questions you probably face, especially in barristers' interviews where professional ethics are front and centre. The temptation is to give a grand, dramatic answer, but the most convincing answers are often quite simple and personal. A time you told a supervisor about a mistake before they discovered it. A time you flagged a concern about something in a team project even though it was awkward. A time you chose the harder right over the easier wrong. Think carefully about your evidence bank for this one. It needs to be genuine. And if you don't have something in a professional context, it's okay to go to the personal context. It might be that you found a wad of cash and you handed it into the police. It might be that you had to tell a close friend that her boyfriend was cheating on her. Sometimes it's difficult to go back and identify these specific situations, what happened, what you did, what you learned, and how that can add value to the particular place that you're applying to. And that's why the task of setting all this out in an answer bank is really, really important. And I don't mean that from the context of making your answers rehearsed, but I mean that from the basis of sometimes it's just really hard to remember. And when you've thought about it and you've remembered the particular situation and you've got a prompt and somewhere to look back to remind yourself of that particular situation, you're not scrambling in an interview, anxious, worried, frustrated about, I can't think about a specific time. There's hundreds, but in the pressure of the moment, my mind's gone blank. You're not going to get to that situation because you have done the task. And your answer, it needs to be genuine, of course. You cannot answer an integrity question in a dishonest, disingenuous way. Why do you want to be a solicitor or a barrister? And I can say this all the time. It seems like the easiest question, but it's actually one of the hardest to answer as well, because you think that you're expected to have this really compelling, novel answer to it. Most students get it wrong because they answer the question like they think the answer should be answered, rather than their genuine reasons why. The wrong answers are vague, list things that you find interesting about law. The right answer is specific, evidenced, and personal. It links your experience, your values, your personality, what you've done, what you've observed, what resonated with you, what you learned, to a clear sense of why a particular profession is right for you. And again, should be honest, if you've had moments of doubt, that's okay. What matters is that you can articulate why. When you weigh it all up, this is where you want to be. So by way of example, my answer was I didn't want to be a barrister. I wanted to be a dancer, but unfortunately I became pregnant and I wanted a career that didn't have a ceiling. And I loved the performing element aspects of the bar, coupled with the intellectual rigor, the being self-employed. I wanted my merit, my reputation to be built on what I did, and I didn't want to be building that for somebody else's name. Why us? Why this chambers? Why this firm? This question is testing your preparation and your judgment. A good answer requires genuine research, not just the website, not just the rankings, actual engagement. And the only way that you can get some of this engagement is by doing some of the steps that we've already talked about: networking, work experience, turning up to court, doing essays, getting your name out there so that you are in the rooms where the stuff that really makes a difference is spoken about. So actual engagement with the particular set of chambers, that helps you understand what the culture is, what the ethos is, with firms as well. Speaking with past trainees, past pupils, getting their view on what was good and bad about the particular pupillage experience that they had. That is invaluable. If you are not speaking to the pupils and the previous juniors in a firm and in chambers to understand that, then you are really, really missing a punch. Tell me about a commercial issue that interests you. This is where your daily habit of reading the legal and business press pays off. You should be able to talk about current issues, a regulatory development, a significant case, a business trend with genuine engagement and your own perspective. And that is hard if only that one commercial awareness topic is read about in the cram up to the interview. Whereas if you've done wider reading, you have a much more holistic view of the matters, and you are able to bring that in and articulate that knowledge and that experience and that action that you've been taking by referencing it. You're able to not just describe the issue, but analyze it and compare it and resonate that to other matters. What are the competing interests? What are the legal implications? What would you advise a client to consider? This is where you show that you think like a lawyer and not just a student. And we couldn't end this without some common mistakes to avoid. So a few things that I see candidates do that really, really hurt them is, first, being vague. I'm really interested in problem solving. That's not an answer. And if that's your interest, then, bore off. You might be good at problem solving because of X, Y, and Z. That might be something that you value because of X, Y, and Z. But they're not interested in the problem solving. They're interested in the X, Y, and Z. So if you're cutting it short there, you're not telling them anything about you. A better answer is, during my mini pupillage at X Chambers, I observed the drafting of a skeleton argument in a complex commercial dispute. What struck me was the core problem wasn't identifying arguments, but selecting and structuring them in a way that would be most effective and efficient for the judge and the time allocated. The barrister focused on clarity and the rock-solid arguments that he felt he was able to prove, which ultimately strengthened the overall submission. I encountered a similar issue in my own studies when I prepared for a mooting competition. My initial approach was to include every arguable point, but in feedback I was told it weakened the overall submission. I was able to then rework the argument by focusing on two central issues, structuring them clearly and linking each point directly to the outcome I was inviting the court to reach. The result was much more persuasive, and it reinforced for me that effective problem solving isn't identifying more arguments, but about exercising judgment and knowing how to prioritise and how to present them in a way that genuinely assists the decision maker. Second, underselling. So many law students have done genuinely impressive things and then they describe them as if they were nothing. Own what you've done. Own your story, not with arrogance, but with appropriate confidence. Your story, in fairness to you, is all you have. You did it, it was hard, it meant something, say so. Third, over-preparing the words rather than the thinking. Candidates who have memorised their answers word for word come across as robotic. What you want to have is your stories so well understood, so thoroughly processed, that you can tell them naturally, in whatever order the conversation demands, and respond to follow-up questions without missing a beat and without becoming nervous, which is the most important point. If you've got a word-for-word answer and you miss a word and you've gone off track and you're off peak, it's not going to do you any good. Fourth, not preparing questions to ask the interviewers. This is a bit of a grey area. The end of the interview is your chance to show genuine curiosity and engagement. If you don't have genuine curiosity and engagement and you don't have anything to ask, then don't just ask a question for the sake of asking a question. But if you are genuinely interested in something, prepare 3 to 5 thoughtful questions. Not something generic, what does a typical day look like, because you're going to embarrass yourself, but something that shows you've thought about the work, the culture, the direction of the firm or the chambers. If they have a particular growing area, people not applying to that, is there scope for you to do some shadowing if you were successful? Do they encourage that kind of thing? Those kind of answers, things that you genuinely want to know, not things that you can find out on the internet or by doing your own due diligence. And as I say, don't just ask a question for the sake of asking a question. So let's bring this all together. The legal profession is not looking for perfection. It's looking for potential. It is looking for character. It is looking for someone who, given the right training environment, will grow into the lawyer they can trust. And the beautiful thing is that this is something you can actively build right now, wherever you are in your journey. Be curious, read widely, get out of the lecture hall and into the real world of law as often as you possibly can. Do pro bono work, moot, mini pupillages, vacation schemes, open days, the list goes on. Build relationships with people who are doing the job you want to do. Write, reflect, and then when you get to the interview room, tell the story of all that clearly, specifically, and most importantly, honestly. You are building your case every single day. Make sure it's a good one. Know your brief. Before this episode ends, I want to give you three concrete things to do this week. 1, start your evidence bank. Sit down for 30 minutes, write out every relevant experience you have, and keep coming back to it if you need to. Every piece of work experience, every role, every challenge navigated. Don't edit yourself. Get it all down. 2, set up a legal awareness habit. Find 2 or 3 sources you can dig deep into for 20 minutes a day. Law Gazette, Bar Council, whatever takes your fancy. Set a reminder if you need to and make it non-negotiable. Apply for something. Mini pupillage, vacation scheme, open day, essay competition. Again, the list goes on. Whatever is right for you where you are at right now. Don't wait until you feel ready. Apply and the preparation will come from the application. Thank you so much for listening. This has been Building Your Case. Know your brief. And I'll see you in the next episode. And do a girl a solid. If you liked this episode, please leave me a review. It really does matter. Like, follow, subscribe, and share. And I will see you next time. Bye.